attorney here at Altitude Community Law. Thank you for joining us today for our presentation of enforcement pitfalls. As many of you have come to know, we've got a little bit of housekeeping we have to get through here really quick. On your screen, you should primarily be seeing the PowerPoint presentation. You should additionally be seeing a small box on the left-hand side of the screen with me, your presenter, in it. On the right side of the menu, you will see a private chat icon. Please use this icon to type in your questions throughout the presentation. Questions will be addressed at the end of the webinar, time permitting. If you have any audio or video issues during the presentation, please click the No Audio or Video button below the PowerPoint on your screen and follow the instructions. One CMCA credit certificate will automatically be generated and emailed to you within 24 hours after the webinar, assuming you have attended the entire program. These credits are not transferable. Please save the image of the certificate that is in the body of the email if you wish to preserve the image. To save the certificate, right-click on the image in the email and save it as a photo. The image of the certificate in the email will only be available for 30 days, or you can always print the email with the certificate. As a reminder, this presentation will be recorded and added to the Altitude YouTube channel within a couple of days. And very lastly, there will be a survey that will pop up at the end of the webinar. We truly appreciate, and I certainly do appreciate, any feedback that you can provide. Your thoughts and opinions assist us and me with improving our future presentations in this very contentious area of the law. So please do not hold back. And without further ado, let us begin enforcement pitfalls. It's that time of year. Everybody is out maintaining, in most instances, sometimes not, their homes, adding improvements, making things generally better. Now, what do we do when that goes awry? Typically, that answer is going to be enforcement, which can be a very wide-ranging subject, and we do have a lot to get through today. However, please be aware, and as always, feel free to use any of our additional resources. We do have our website at www.altitude.law, in which we host a lot of articles specifically on this subject, as well as many others. And I would always recommend reviewing this article here, Successful Enforcement of Covenants, Rules, and Architectural Standards and Guidelines. As always, we do have our blog that we post every month, and I would also recommend for those of you that have new board members or board members that are just getting on and are given a lot of grief about why certain things have to be done certain ways, I would always recommend our board member basics. Those are always going to be covering a wide variety of topics, and I typically tend to teach the enforcement provisions every May and October. So I would always recommend that if they need a deeper dive or more specific attention. So we're going to start with some very, hopefully, familiar ground in the hierarchy of documents and law. Very typically, and many of you already know, federal and state law is always going to control, right? That could be, in some instances, the Fair Housing Act, Colorado Anti-Discrimination Act, even though we're not getting into those today. Those are just some examples. Federal and state law are always going to trump, or Kiowa would be a very good example of that, your declaration, which is your associations, your communities, essentially declaration, if you wish to think of it in those terms. Beneath that, the Articles of Incorporation. Beneath that, the bylaws. Beneath that, the rules, guidelines, and policies that are, in many instances, required to be maintained and adopted by an association. Now, what about ordinances? Well, with ordinances, we're referring to municipal or city ordinances. We will get to those, but the answer should not be surprising. So what you can enforce, obviously you can't enforce federal or state law. You are not the government, and your associations are not the government. You can enforce your declaration, your bylaws, your articles of incorporation, your rules, architectural guidelines, and your policies, right? And they're again in that order of what will be given the most importance in a courtroom, as well as, how hard they are to change, which kind of dovetails into why there is that hierarchy there. Remember, rules, architectural guidelines sometimes, and policies are all adopted by the board, right? And you can't work to amend your declaration through a rule or regulation or policy. Same thing with bylaws that'll provide for the blueprint for the day-to-day operations of your community. Member voting, a lot of times that'll be board terms, qualifications, things like that. But what we can enforce, again, federal, state law, local, city or municipal ordinance, official development plans, or planned unit developments, and again, ordinances. Many times I get asked, what do we do when somebody's breaking the law in the association? That answer is going to be refer it to the police in many instances. Now, you might be asking why official development plans and PUDs can't really be enforced, even though they kind of touch and concern a lot of associations. Ultimately, these are zoning regulations, and the enforcement is up to your local government in those instances. So because you are not the government, you cannot enforce an ODP or a PUD. So what happens, and we touched on this a little earlier, what happens when you have rules and regulations that contradict what's in the declaration? And when the documents do contradict each other, obviously there's going to be some sort of problem there. You need to go back to the hierarchy and look for guidance. If a rule and regulation is contradicting what's in the declaration is going to hold more weight and is most likely going to be the most credible guidance there. But if that doesn't help, because developers do a lot of favors for us when they draft these declarations and governing documents, please call your attorney to help decipher which is going to trump, and as well as that's applicability to current law. With regard to board members, standards of conduct and your duty of care, remember when you have board members that are acting a certain way, it is always very helpful to remind them that there is a duty of care assigned to their position, and a director is required to discharge their duties in good faith with the best interests of the association while being prudently informed. What does that mean? You have to do your best for the association, not individuals within the association. And you have to come to an informed decision. You have to ask what the right path forward is. That will generally avail yourself of the business judgment role as a director. Now, remember, a director is not liable to an association or its membership for any action taken or not taken, omitted, if the director, again, acted in good faith with the best interests of the association while being prudently informed. So if a director goes through how this should work out, if a director goes through all of those steps, acting in good faith, acting in the best interest of the association while being prudently informed, and something doesn't pan out, or something, best laid plans, then that director or individual directors should not be held personally liable for that mistake. Sometimes things happen, just so long as we are being prudently informed and acting in the best interests of the community. But now that we've made it through, that brief refresher on what we can enforce, who we are, and how we have to go generally, or the attitude we have to take forward with enforcing our declaration and governing documents, let's get into some of the tools and pitfalls that we tend to see around this time of year. I mentioned policies earlier. The enforcement and fine policy is something that every association absolutely should have, because courts, even if it might not be technically required for some of your associations. Courts expect to see it. And it only helps, right? It provides a roadmap. What do we do in this instance? You will need it absolutely in place to levy a fine. That's pursuant to 20951B42, which is a mouthful. And that is a requirement of the law. But the basic components of this policy should include reporting a violation. Who can report? What are we going to do when somebody reports a violation? Does that report need to be in writing? The investigation. Now, for a lot of my Kiowa communities, that is going to be absolutely a necessity pursuant to, again, that 2095 portion of the statute, which necessitates your fine policy and your enforcement policy. Which requires an investigation. How are you going to investigate? Who's going to investigate? And when you are going to investigate. As well as if you are going to levy a fine, you must provide, and this should be in your roadmap, the notice of the violation and the right to a hearing, or the opportunity for that hearing. That should all be included in your enforcement and fine policy. If those are not, I recommend getting in touch with your attorney sooner rather than later for some of the reasons that you will begin to see a little bit later on in this presentation. When we discussed a fine, right, when we're talking about, or not a fine, a hearing, that should also include some roadmaps as to who the impartial decision maker is going to be. In many instances, that is going to be the board. However, if that becomes too contentious of a position, your enforcement policy should lay out who will be that impartial decision maker, or how that impartial decision maker will be collected. It should also lay out in general terms what your hearing procedure is going to look like. Is that going to be in front of the board? Is that going to be in front of a committee? Is that going to be in front of how many days? Please allow me to apologize. How many days is your board going to have to issue a determination? You're also going to want to make it painfully clear to your membership what the fine schedule is going to be. Now, again, this used to be a more Wild West type consideration. Your fines could be whatever they wanted to be so long as they were reasonable. However, after 2022, with the passage of HB 221137, reasonableness became a defined term for you, meaning that, or for many of you, meaning that you are limited to $500 total per violation, which, it can be a little bit difficult to navigate when you have a lot of violations going on, but that is generally going to be the accepted and required cap on violations. With regard to notice of violation, now this is a tool, this is a required tool, and I see it as a pitfall a lot of the time. What does a notice of violation, your violation notice, what does that have to require? Well, what should be made plain, and what I see happen a lot of the time, is that it needs to go to the unit owners, right? Very often what I will see, and this can be hard to keep track of, right? But very often what I see are violation notices that are sent to one unit owner when there are in fact two or three. A violation notice will need to go out to every member or every unit owner of record on an association. And if you need to ask, it's an easier conversation to have that ahead of time than when you are issuing your notice of violation, turning it over to your attorney for an enforcement, and they are coming back with, you need to start this process over again because you failed to list another member that you might not have known about. But your notice of violation, apart from that, should describe the rule violation, right? What have they done wrong? And it should restate the rule. If you're going to say that they have violated a rule, they should know what that rule is specifically that they have violated. State your possible penalty. That could be a fine. depending on what stage in the process you are at. It could be that this is going to be escalated to an attorney, but let them know what the consequences of their failure to act or in a certain way or violated. Let them know what those consequences are going to be. And request specific action to be taken by an owner. Generally, the more specific, the better. Because if something gets too vague and nebulous, like, I don't know, fix it, right? That can leave a lot of questions and a lot of frustrated unit owners who truly want to do the right thing. They're just not quite sure what the board or what the association or what the covenants are going to require. A lot of violators won't have that in-depth knowledge like the board has or like many managers have. So be specific. If a lawn needs to be maintained, does it need to be weeded? Does it need to be reseeded? If a house needs to be painted, is it just maintain your property? Is it paint your house? Be specific. Let them know what you want them to do, and it'll make hopefully their job easier and hopefully lead to compliance before it gets escalated. Again, those consequences of not taking action, speaking of escalation, that could be very much it coming across my desk. I mean, let them know if you're going to send it to an attorney when you're through with your enforcement policy. If you are going to levy a fine, absolutely you must provide notice of an opportunity to appear at a hearing for the board of directors. And again, I would put those consequences of not appearing at that hearing, which could be very well that, just like in a court of law, that because you weren't here, we are going to find that you are violating and issue a fine. So those should be in every notice of violation that an association sends. And oftentimes, there are a lot of violation notices that are lacking. But that would be the first pitfall. Get those violation notices in order. Of course, there will always be defenses, especially in this year, 2026. There are a lot of fights going on. And a unit owner can absolutely challenge a decision of the board of directors or an enforcement action. A part of that is going to be to challenge the covenant, rule, or guideline. Remember, as a basic tenant, your covenants must be reasonable, right? As often as I like to use, can't wear red on a Tuesday, right? If that's a covenant, then that's a covenant. Is that covenant going to be enforceable? That's very much going to be up to a judge's determination if the matter goes to court, because a judge can always look at something and say, I don't think it is reasonable that anyone should be prohibited from wearing red on a Tuesday, right? And again, if your rule or guideline contradicts what's available or what is in your covenants, then that's going to be a problem. Because if you're trying to enforce something that you didn't have the authority to enforce or that the declaration specifically provides, that would be a very excellent defense. And remember, rules are going to be subject to stricter scrutiny than covenants because covenants are recorded. Covenants are slapped with a stamp. They are given to a lady or gentleman. They are given to a person in a room and that nobody goes to, and everybody on the entire planet has notice of what is contained within that recorded document. They are hard to amend, I'm sure as many of you know, and require owner buy-in to amend, or at least an owner vote. Rules are adopted just by the board. And what the board cannot do is amend its declaration through rule and regulation. So when you are writing and drafting rules and regulations, you want to make sure that they are leaping off of the declaration instead of rewriting it. Again, they can challenge procedure. That's another thing that we're about to get pretty in-depth about. Abandonment and waiver, those I see a little bit less. Abandonment is when nobody has enforced a specific covenant in decades, and there is no hope of retaining that covenant. So imagine you're in an association where every house must be painted white. And over the years, less and less enforcement has gone on to where maybe 1 or 2 houses are painted white. Under those circumstances, very well could be that covenant is considered abandoned. And waiver, that can happen for a lot of things, for a lot of reasons. Maybe the board misses a violation and it gets statute of limitations out. There's nothing you can do at that point. That's what a waiver would look like. There's always, of course, latches and estoppel, very much kind of the same thing. Latches happens when you notice something and fail to do anything about it for years and years and years. That would be what a latches defense is. Kind of the basic premise is, well, it didn't bother you 5 years ago. Why is it bothering you now? Estoppel, promissory estoppel, is very much, you told me I could do this, I did it, and now you're telling me I can't do that. That would be the defense of estoppel. If you tell somebody they can do something and then they do it, you can't really fault them for it. Selective enforcement, we see this one brought up all the time, very rarely actually a worry, because every unit owner will bring up selective enforcement because they are always feeling acutely picked on, might be a little bit strong there, but they're always feeling singled out. Selective enforcement is very much you are enforcing the covenant in an uneven, unhanded manner, specifically, and not against some people and only against some people. That would be selective enforcement. And statute of limitations, that is going to be your big one. That is 3833.3, 123C of the Colorado Common Interest Ownership Act. You have 1 year for any building restriction. And building restriction is a little bit different than maintenance, right? If I change something in the building, if I paint it, if I paint my house, I always like to use this color, I don't know why, neon pink, and nobody does anything, if I am not taken to court 364 days after I have done that, and then the association tries to sue me, I will be able to have that dismissed as it is beyond the statute of limitations. Now, the statute does say from date of discovery, knew or should have known. That is because typically, if there's anything under the association's remit, it's going to be the outside of a home. If something is changed on the outside of a home, the date that they start making that improvement is going to be the date the association knew or should have known. Same with condominium associations. If someone is installing a hardwood floor, which is against the covenants, very likely the date that they are installing that, because it takes a crew and it takes a lot of material to get that through a condominium building, in a lot of instances, the date of installation is going to be your knew or should have known moment. Then there are continuing violations like failure to maintain, right? There's not a statute of limitation against really requiring somebody to mow their yard, to paint their home, to maintain their property. And that's what we mean by continuing violations. Those violations that aren't necessarily building restrictions, but are still obligations of the unit owners through the covenants. Now, many of your declarations, and this is going to be my kind of second pitfall, right? Many of your declarations, they're all going to be unique. And that is the second pitfall, is treating every declaration like it is the same document, like they all read the same. There are a lot of general themes, right? But no two are identical. Some declarations will have required alternative dispute resolution. That'll be arbitration, that'll be mediation. That could be a number of things before you're allowed to typically kick it over to your attorney. Arbitration is expensive and it does take a long time, but so does county court and so does district court. Mediation takes a lot less time, harder to schedule than it is to do, in my experience. and is a lot shorter. And when to use these? When do you use these? I mean, I would recommend using them if you are required by your declaration to use them. I would also recommend in instances that if something is really simple, that mediation could be attempted. Although if you are in a enforcement action and more often than not in county court, you will be required to mediate, so that'll be part of that process. But do be mindful that many of your declarations do contain mandatory alternative dispute resolution articles, and failing to go through that process could be disastrous for any enforcement action that the association is contemplating. So do be aware of those. So we had touched on this topic a little bit earlier, and we're in court. What is a judge going to look at? And I end up giving a lot of advice on what the judge is going to do with it. The judicial standard of review is going to start with, is the rule or the covenant enforceable, right? Was the declaration recorded and adopted properly? Was the rule and regulation adopted properly? Are they clear and unambiguous? Because if they are ambiguous, I can tell you that the court's going to lean in the direction of the homeowner. That's the case law. And then after that, judge is going to look at, has the association followed its procedure that's required? Again, likely that's going to be by an enforcement policy that is dictated by Kiowa. Or did you follow your policy? Did the association act within its scope of authority? Is it acting reasonably and in good faith in pursuing enforcement of these covenants? That's what a judge is going to look at. Do you have the covenant? Is the covenant reasonable? Have you done everything by the book? Or has there been a very, very good reason to have not done that? I've not seen many that exist anymore. And have you been acting within the scope of your authority? Have you been acting? Are you pursuing this in good faith? Or do we particularly hate Bob and what Bob is about? So that's what a judge is going to look at. But when it comes to our third pitfall, or at least the one that I see again more often than not, is going to be some sort of breaking down in the architectural review process. Now, again, this is all going to be very document specific. So while we can give some very general guidelines here, the architectural review process is going to, or should be, contained within your declarations. And again, each declaration is a snowflake, and each declaration is going to require that bit of understanding. So who makes the decision under architectural review? Review that declaration and determine who has the authority to act. Some declarations will have a architectural review committee that must be appointed by the board. Sometimes members of that architectural review committee must be voted in by the membership. Sometimes they all have to be volunteers. That is going to be our first stop, is seeing who is on the Architectural Review Committee or the DRC, and I will start reviewing to them as ACC or DRC. That would be Architectural Control Committee or Design Review Committee, respectively. They both generally very much mean the same thing, or at least I've never understood any real distinction between them. However, the Board of Directors could also have that authority to be effectively the ACC or the DRC. So check those declarations. Make sure we understand who is going to be reviewing design applications and who is going to be giving approvals. And also, additionally, another one is ensure you know who, in that instance, has the authority to promulgate, to put out design guidelines and rules and regulations surrounding the design of the property. Many times that is going to be the ACC. Many times I see that being the board itself. Just make sure you understand who the players are and what their bounds are with respect to their role. And that should be contained within your declaration. So the ARC, DRC, ACC, and we have this alphabet soup of different committees that all very much have the same job. The committee is going to, again, review and approve or deny design applications submitted by members. Again, who appoints them? That could be the board of directors. That could be the members themselves. It could be an entirely volunteer position. Can they be one and the same as the board of directors? Yes, absolutely, if that's what your declaration requires. Oftentimes not. They are kept in very separate houses, but they can be the same. Again, you will have to review your declaration to ensure that you have the right people and that they are acting within the scope of the authority provided to them under the declaration. There are generally 3 steps in the architectural review process. There's going to be receipt, review, and response. And this is where things can start breaking down. Receipt. Okay. We have a member. That member wants to make a change to their home. They will provide, or should provide, in many instances, an application. That application should have the date that they are submitting that application, their name, address, phone, fax. I actually have had a few members that do use fax more than they use phone or email. Strange. As well as a description of the work to be performed, the kind, shape, height, materials, and color. Now, this is going to be the first general piece of advice is demand specificity in your application. We were talking about promissory estoppel earlier, and I said we would be talking about it a bit more, and here's why. You want to demand specificity in your application. So if I provide an application, has my date, my name, and my description of the work is that I'm repainting my home, and that's all you got. What does that actually tell you? What does that tell you that I'm requesting? Well, clearly, I'm hopefully wanting to paint my home, presumably a different color, could be the same color, just repaint, but you won't know. Some applications do require fees, and that fee should be enclosed. Some application processes require multiple copies. Make sure you have all of those copies. Some applications will request a variance, which is a bit of a separate issue, but we will come back to that. Their planned date that they start or would intend to begin the installation of whatever improvement they are requesting, and their planned completion date. They should also include, in many instances, attachments, construction plans, architectural drawings, elevation drawings, specifications, sample colors, sample materials. Again, if this is something that is, in many times it will be spelled out in your declaration, but to the extent that you have leeway, those boards or managers who are advising them, you have leeway to adopt rules and regulations or design review policy if your declaration allows it. You want to start requiring this level of detail, because if you want to know specifically what somebody is wanting to improve and install on their property, you have to ask, right? Because, like I say, once an approval is signed, you get what you get, right? So if I give to you my application and it has, again, it just says I'm painting my house gray. Let's put it that way. I'm painting my house gray. So I'm intending to paint my house gray. There are hundreds of shades of gray. Some of them might be objectionable, some of them might not be. But if that application is approved, if I have the board's signature on that, then I've got permission to paint my house gray. Now, that is kind of the thing that many of you may need to remind your members of, is that these applications, this this process is as much for their benefit as it is for the boards, right? The board has a record of, we have approved this thing to be done, and the member, our unit owners, have a record of, you told me I could do this. But it works better. That entire process works better when you demand a specificity, because the last thing you want to do is end up in front of a judge down the line saying, well, we had this verbal understanding, and verbal agreements are worth the paper they're written on, right? And then it just becomes a very fact-specific intensive inquiry, essentially, where both parties are arguing to somebody unrelated who is going to make the decision for them, right? So specificity, demand it. If we want to have that much control over what exactly is put in our community, right? Additionally, photographs, landscaping, grading, plot plans, the acknowledgement. This is another thing that I see relied on a little bit too heavily. Do not rely on your acknowledgement. Many application forms do have them. And they'll say something like, owner states that they will comply with all covenants, right? The signature is required, and then we end up in situations where we have this kind of ambiguous at best design request that's been signed off on. And if something changes, something doesn't go according to plan, you're not going to be able to treat that acknowledgement as an insurance policy, as a catch-all, right? I mean, ultimately, we have a signed document or an approved document that people have been tracking, and it will have the permission to do specific things. Now, if there's something completely off plan, right, that's not included in that plan in any way, reasonable way, shape, or form, that's going to be a different story. However, we cannot rely on this specific type of language as a sort of catch-all insurance policy that'll make it so you can force against everything if it turns out that it's not precisely what the unit owner had intended to install. What does that require? That might require, to address that situation, that might require enforcement of a particular matter. That might require, communication from the board or the ARC with the unit owner. There are a lot of things. We just cannot rely on that essentially kind of waiver of rights, if you will. It might be a little bit grandiose, but that's what we're going to call it. Now, when you are receiving these, right, many managers note it down. Nothing is more frustrating than, and everybody does at some point, right, receive something, then a fire happens next door, and oh my god, we gotta do this other thing because this is the actual emergency. Bob, your proposal can wait. And it absolutely can in that instance. Make sure you are giving out receipts, right? And when somebody submits an architectural review. And part of the reason for that is it can be very easy to lose when a submission is completed, and do not give out this receipt until it is completed. And it's going to guard against a waiver argument, right? Oftentimes what will happen is, someone, and this is a tricky thing that's in a lot of your in almost all of your governing documents, there will be a timing provision. And that pesky little provision will provide in 30 days. Now, typically, the language I see is that if not approved in 30 days, it is automatically denied. However, it could also be the flip side of that. If not approved in 30 days, then it is approved formally. And there is no need to comply with the remainder of the covenants in that instance. So part of that is tracking when the submission is complete to the board's satisfaction, because you can't consider something until it is complete, right? And it is to guard against waiver arguments, right? I hand you a receipt after you've been supplying me years of incomplete records or design review requests, and I am telling you this is when your time starts. This is the date that counts, not any of this other time where you've given me just you're asking for permission to paint something. I don't know. That's why I always recommend that. Make sure you have your checklists, right? When you get an application, make sure that, again, everything is submitted, the required attachments, any copies, any fees. Make sure you are keeping track of the status of that submission. And to a few earlier points, if something is not complete, right? If something is incomplete, you receive an incomplete application, send it back to the owner with the request for additional information. Let them know that it is incomplete and that you need more. And always, always, always do this in writing, right? Again, verbal agreements are worth the paper that they're written on. And it can lead to a lot of confusion if you're just calling members or anything like that, saying, hey, this isn't complete, send it on over. And then 60 days goes by, we haven't gotten our receipt. It makes a mess, right? A mess that can be very hard and difficult to untangle factually later. So when you are sending an incomplete submission back, always make sure you get it in writing, and always make sure you are telling them exactly what they need in order to get that design review application under consideration. If it is complete, send it on to whichever body is responsible for reviewing design requests. If that be the Architectural Review Committee, the board, or a mix of both. Once it's complete, give the receipt, send it on to the board, and keep everybody updated as to the status of that submission. And then we get to review. Okay, so again, is this something that's going to be reviewed by the ARC or the board? Again, and this is kind of the running theme here, make sure you read your governing documents or the document that sets up the ARC or the DRC or the ACC, and make sure we know who has that authority. Sometimes it is the ACC and the board wants to get involved and they can't because of their declaration, right? So make sure we understand those boundaries, who has that authority to act and approve what when. And when a submission gets to the ACC, what they are doing is effectively comparing the application substance to factors in the governing documents for approval or disapproval, right? Part of that is going to be, is what they're requesting something contemplated by the declaration? Is it something we absolutely have to let them have? Is it something that is strictly against the declaration? Is there a good reason for a variance to be granted if that is the case? And then you're also going to compare applications to prior approvals given by a board for consistent, or by the reviewing body for consistent application. Because again, you want to stay well away of any selective enforcement arguments, right? You're going to be looking for, is it allowed by the declaration? And do other people have it? Or have we allowed it in the past, right? Because if you've allowed it in the past and you've not alerted your community to, hey, this is what's happened in the past, new board, we have this covenant, we are going to be enforcing it. And if you don't tell your membership that, right, then it starts to look a lot like selective enforcement, at least to other outside parties. If Bob gets his pink house and I don't, right? That's why we are always keeping records. And is that decision going to be within the scope of the Architectural Control Committees or DRCs or board's authority? Did the committee approve a design that will violate an absolute restriction, right? If we have a declaration that requires all houses to be white, and Bob has his hot pink house, and that was approved, was that approval within the control committee's authority? Was that or denial based on municipal code? Is that an appropriate denial in that instance? Did the committee reject a design by applying a restriction more stringent than the simple absolute restrictions in the covenants? These are all factors that could go into when you're explaining why something was denied. Could come back if we're not paying it. Could come back to bite you if we're not paying attention to the process as laid out or the covenants themselves. And again, the reason for denial is can be just as important as the denial itself. And make sure you are spelling that out when you are denying something. But let's talk about those design restrictions. Because again, this can also be problematic, right? I mean, I think a lot of us get into this type of, we understand generally what these design restrictions are about, but what does the actual language say? Simple and absolute restrictions are always going to be your friend. Those are going to be shall not, will not, cannot, right? Do not. Those are always the best, all right? Because it lays out expectations of what can and what can't be done, right? You cannot have a fence. You must have a fence. That fence must be X, Y, Z, as opposed to, and again, that is hopefully going to be in your covenants, or it might be in a rule, assuming that your covenants give that type of authority over to your architectural review committee or to your board to promulgate those design guidelines. Is it going to be a complex and discretionary restriction? The more based on our feelings type of discretion that I would tend to discourage. Because the more arbitrary it comes, and that's going to be that is a word that is finally coming up in this. Remember, your duty when these are all said and done is to act in the best interest and in good faith, right? Contrary to good faith, we have arbitrarily or capriciously, right? And if a board or an ARC is denying something arbitrarily or capriciously, I hate pink. Bob can't have pink house because I say so. That's going to be a problem. But what will lend credence are these design restrictions created by a committee? Are they only promulgated by the board? Is there any owner input into it? Those are all important considerations when we're looking at the type of language that these design guidelines have. And remember, encouraged, words like encouraged or should are discouraged, right? Because that you can encourage me to do something all I want or all you want, and I don't have to do it unless the rules say I have to do it, right? You can encourage me to have a 3 picket or a picket fence or a free split rail fence, but there is no requirement there. It's just a, hey, we'd really like to see that done. That's fantastic. You'd have to point me to the rule that says I have to do it in order to receive consideration or approval. So just be clear, really, when you're when you are crafting your design restrictions. Again, always recommend providing them to your attorney if you have questions on the language, because they can guide you towards best practices. However, we do encourage. We do prefer, and I think everyone does prefer, absolute, simple restrictions and language. Do not, cannot. Don't encourage. Don't suggest. And then we have the response, right? Again, this is where prime time starts to come in. There are really only 4 options when it comes to a response within the deadline period. Again, read your declaration. Make sure you know if it's everything is denied. If we don't respond within the appropriate amount of timelines, make sure it is not everything is approved and nothing further need be done on the unit owner. If we don't respond, be very conscious of that timeline in your declaration. But you will only have generally 4 options. It's going to be approve outright, approve conditionally. You can do this, but you have to do X, Y, and Z as well. Or you can't do X, Y, and Z. You can deny it outright, tell them to resubmit, or you can grant a variance. However, granting a variance is not a given. It's not an absolute right that the association has. It does require specific authority in your declaration, and some declarations are much stricter than others. So if you're going to grant a variance, make sure you do have the authority to do so. Otherwise, you might have to deny it, or amend your declaration to allow you to have that variance. And you must have that authority in your governing documents, just as and you have to consider the long-term effects of a variance, right? Is something like painting maybe something that's not going to have too long of an effect? Maybe. People change house colors all the time. But you want to consider the long-term implications of whatever you may be granting a variance for. Because you're going to be asking, because I can guarantee you other unit owners in the community, if they like it well enough, will start asking for their own. And that becomes, one, a pain to try and navigate around, right? Or if there is, because you're trying to deny one person one thing and trying, when you've already provided it. But if you have to, give it sparingly. It's with great power comes great responsibility. Do use it sparingly if you have to, and be consistent, right? Same set of facts, 2 unit owners. There should be no reason, and you're going to grant a variance for 1 unit owner. A variance should be granted for another unit owner. A variance is not a tool that just says, Bob, today I like you, you can have it. Jack, you're out of luck, because now we've directed our ire towards you. Be consistent if you are going to give a variance. And sometimes there can be other very good reasons for giving a variance. That could be federal law requires you to, FHA type restrictions, right? Or Fair Housing Act, Colorado Anti-Defamation Act. Those would be the 2 biggest ones that I would imagine require it. But just make sure we are using that authority sparingly. Notices and letters, again, very much like your enforcement policy. If someone is violating their submission or breaching their submission, however we want to call that, remember to send your warning letter. If somebody starts building immediately without having submitted to the design review committee or the architectural control committee, send a cease and desist letter. Right now, this is going to be a little bit different from your enforcement policy. Years past, it used to be that cease and desist letter was the initiating of a process. You still have to make it through your enforcement process, but giving them notice that, hey, we know what you're doing. We're putting a date on it, and we are telling you to stop. That can be very impactful. All right, stop what you're doing, submit your design review request, and so we can consider what it is you're trying to do without this becoming a bigger uphill battle. Remember to send out your violation notices, the right to the hearing, the potential fines, and yes, follow your enforcement and fine policy. The worst thing, and what I see a lot of associations do, is not want to start the enforcement policy. Then the matter drags out for a year, and then you're past your statute of limitations, so it doesn't matter, right? Get through your enforcement policy first and foremost. Appeal. Some documents do allow for an appeal. That's going to, again, be document specific. There's no statutory right to it. So if it's not required in your declaration, a unit owner does not get one as a matter of right under the Equal Protections Act or the Equal Protections Clause or the, I believe, the 14th Amendment, right? That is not a statutory or constitutional privilege. That is a document specific privilege. If the authority exists, do it. If someone, again, it's not that these are ever foregone conclusions, right? But if somebody requests an appeal, give them the appeal and let them make their case, right? So I've got 5 minutes for questions. I'm not going to be able to get through a majority of these. So if there are any unanswered questions by the end of the next 5 minutes, please feel free to shoot me an email at jfletcher@altitude.law, and I will be responding as soonest as I can. And we'll try to generally provide best advice, right? Or best practices. That's what I meant. So let's take a look. Speaking of preemption by federal and state law, please discuss how emotional support animal letter from a doctor overrides HOA rules, restrictive covenants, even local city ordinance. What you're referring to there is the Fair Housing Act. And the Fair Housing Act is a federal law that as well as the Colorado Anti-Discrimination Act, which is growing more teeth. Very much they're the same for our purposes. You can consider them generally the same law. And what that is the legislature saying, hey, people who meet the definition of disabled are entitled to use and enjoy their property just as much as anyone who is not disabled would be. Emotional support animals, we do offer a course on that later, and we can get into much more detail on that, as well as discrimination practices in general. So I would tune back in. We have a condominium association. Unit owners are responsible for the maintenance of their windows, subject to architectural approvals, primarily as it relates to exterior colors. How do you handle the situation in which the ARC committee approves an ARC request for a window replacement subject to matching existing window exterior color, and the owner installs windows with an exterior color that knowingly does not match? To my mind, that sounds like a violation. However, I would, absolutely ask your attorney. But if there is a violation like that, then proceeding through enforcement is likely going to be your way. But that is why we keep copies of the architectural submission, right? So we can, if it becomes a problem later, you can show them what you approved. Everyone in our community is very vigilant. RE wildfire risk mitigation. Nearby association assigns a $5,000 immediate fine for just discharging fireworks. It doesn't appear they are aware of the requirements of Kiowa. However, the question, if an association defined this as a public safety, could it find as much? Could it be immediate? What about the 72-hour cure? So what the law provides is that a unit owner must be given 72 hours to cure a violation, and that the association may fine every other day. Apart from that, there's not really, the statute doesn't guide us, and no case law to hand, though, certainly public safety and health, not a little bit beyond the scope of what we're talking about today. Again, we do have a lot of articles on that, and I will be addressing that in board member basics again, coming up, I believe, in October. So please tune back in for that. But with that, we are at, one more. I think I can do one more. Let's see here. If the PUD allows for the construction of a 5,000 square foot building, can the board determine if the appearance of the building must be consistent with existing buildings? can a board remove a fence that was lawfully allowed by a previous board to be removed without due process and compensation for the costs to construct? No. That one is simpler. No. If somebody's already been provided the authority and they have built that fence, we are operating very much in a you break it, you bought it type scenario generally, right? You can't just go on, and I don't think anybody would recommend you just go onto a property and remove something that's been there for a couple of years, right? One, you never know what people are capable of, right? What they're going to do, what kind of day they've had. So there's safety apart from those safety concerns, right? You want to, if you've allowed it and it was put in there by the book with approval, no. But with that, again, please feel free to email me any questions that I did not get around to answering. Thank you so much for joining me this afternoon for the pitfalls of enforcement. And please, again, please, if you could take a moment, fill out that survey at the end of this presentation, and let me know what you think, and let me know how we might be able to improve or not improve this presentation. Thank you, everyone. I hope you have a wonderful afternoon. And this is Jeremy Fletcher signing off.